Welcome to the Reasonable Passers Club, a study space for future lawyers, bar takers, and law students learning the law one rule at a time. Subscribe to join the club, comment with the topics or questions you want covered next, and share this channel with other law students and bar takers. Let's get reasonable. Welcome to the Federal Court Mechanics Blueprint. This overview ties together three major civil procedure topics: the well-pleaded complaint rule, removal, and supplemental jurisdiction. The goal is to show federal jurisdiction as a sequence rather than as separate rules. First, ask whether the plaintiff's own complaint establishes federal subject matter jurisdiction. Second, if the case began in state court, ask whether the defendant can properly remove it to federal court. Third, once a federal anchor claim exists, ask whether related state law claims may come along under supplemental jurisdiction. Emphasize that federal court access is not automatic. Every step has gates, exceptions, and timing limits. Let's look at our three gates. Gate 1 is the plaintiff's initial filing. Does the complaint itself create federal jurisdiction through a federal question or diversity? Gate 2 is the defendant's defensive maneuver. Can the defendant shift a state court case into federal court through removal? Gate 3 expands the scope. Once federal jurisdiction exists, can related state claims be heard too? The core takeaway is that each gate asks a different question. The plaintiff usually controls the first gate, the defendant controls removal, and the court polices the outer limits of supplemental jurisdiction. Start with the well-pleaded complaint rule. Federal question jurisdiction must appear on the face of the plaintiff's properly pleaded complaint. Focus only on the plaintiff's affirmative claims. Do not look to the defendant's expected answer, expected defense, or even a likely federal issue raised in rebuttal. A federal defense does not create federal question jurisdiction, even if everyone knows the defense will be central to the case. For exam purposes, train yourself to ask, where does the federal law appear? If it appears only in the defense section, the case stays in state court unless another basis for federal jurisdiction exists. Use this diagnostic matrix as an exam shortcut. If the plaintiff sues directly under federal law, that usually supports federal question jurisdiction. If a state law claim merely predicts that the defendant will raise a federal statute as a defense, that does not create federal jurisdiction. The same is true if the defendant's actual answer relies entirely on federal law. The answer may be important to the merits, but it is irrelevant to the jurisdictional gate. The main rule is simple. Plaintiff's claim controls, not the defendant's response. Gate 2 deals with where removal must go. Removal is not a free choice of any federal court. The case must be removed to the federal district court that geographically embraces the state court where the action was originally filed. That means the defendant does not simply remove to the defendant's home district or a more convenient district. The correct removal court is tied to the state courthouse where the case began. On an exam, if a defendant removes to a different federal district just because they live there, flag improper removal venue. This slide addresses the Forum-Defendant Rule. In a case based solely on diversity jurisdiction, a defendant who is a citizen of the forum state generally cannot remove the case to federal court. The logic is that diversity removal protects out-of-state defendants from local bias, so an in-state defendant does not need that protection. The key limitation is that this rule applies only to diversity-only cases. If the case includes a valid federal question, the Forum-Defendant Rule does not block removal. For exams, separate pure diversity cases from federal question cases before applying the rule. Removal also has timing and consent requirements. The baseline is that a defendant generally has 30 days from service to file the notice of removal. When there are multiple defendants, all properly joined and served defendants must consent. The later served defendant rule gives each newly served defendant their own 30-day window. If a later served defendant timely removes, an earlier served defendant who missed the first window may still consent to that removal. The practical exam sequence is: identify service dates, calculate each 30-day window, and then check unanimity. This removal matrix turns the rules into quick outcomes. If a diversity case includes a forum state defendant, the likely result is remand under the Forum-Defendant Rule. If a federal question case includes a forum state defendant, removal can still be valid because the rule does not apply. If the defendant removes to a home district in another state, the problem is improper removal venue. If Defendant 1 misses the 30-day window, but Defendant 2 is later served and timely removes, removal may still be valid because the later served defendant can revive consent. Gate 3 introduces supplemental jurisdiction under 28 U.S.C. Section 1367. Once a federal claim gives the court original jurisdiction, The court may also hear related state law claims that arise from the same case or controversy. The test is often described as a common nucleus of operative fact. That means the claims are factually connected enough that it would make sense to try them together. In exam writing, do not merely say the claims are related. Explain the factual overlap: same transaction, same occurrence, same injury, same witnesses, or same evidence. This slide shows the asymmetry in supplemental jurisdiction for pure diversity cases. Section 1367(b) limits plaintiffs from using supplemental jurisdiction to bring in non-diverse parties when the original basis is only diversity. The purpose is to prevent plaintiffs from evading complete diversity by adding claims or parties that could not have been in federal court originally. Defendants have more room. They may often use supplemental jurisdiction for counterclaims, cross-claims, and impleader claims, even where the amount is smaller or diversity would otherwise be disrupted. The exam point is to ask who is asserting the claim, plaintiff or defendant. This slide addresses what happens when the federal anchor claim collapses. If the only basis for federal jurisdiction disappears early, the court usually should not keep the remaining state law claims. Sometimes remand is practically mandatory, especially when there is no independent federal basis left. In other situations, the court has discretion and may consider judicial economy, convenience, fairness, and comity. The important distinction is between having no federal foundation left and having a discretionary reason to keep or remand the related claims. On an exam, identify the timing of dismissal and whether any independent jurisdiction remains. Use this supplemental jurisdiction matrix as the final shortcut. If state and federal claims share a common nucleus of operative fact, supplemental jurisdiction is generally available. If the original case is pure diversity and the plaintiff tries to add a claim against a new non-diverse defendant, Section 1367(b) usually prohibits it. If a defendant brings a related counterclaim from the same event, supplemental jurisdiction is more likely permitted. If the only federal claim is dismissed immediately after filing, the remaining state claims are usually remanded. The governing questions are common nucleus, party asserting the claim, diversity limits, and survival of the anchor claim. End with the access tree. This is the full sequence for analyzing federal court access. Start with the plaintiff's complaint. If federal question jurisdiction appears on the face of the complaint, continue to removal mechanics if the case began in state court. Check whether removal goes to the embracing district, whether the notice is timely, and whether all required defendants consent. Then analyze supplemental claims. Do they share a common nucleus? And does Section 1367(b) limit the plaintiff in a diversity case? The final exam strategy is to move in order. Do not jump to supplemental jurisdiction before confirming the federal anchor and removal requirements.
If you want these slides as a study aid, comment slides below and I'll let you know how to access them. Subscribe for more lessons, bar prep rules, and exam-focused explanations from the Reasonable Passers Club.